and I'm going to go ahead and start recording. And today is the first official monthly meeting of the Fair Housing Forum, which has been in effect for quite a while. Brian Dale, who's on the call today, is with HUD, and he was sort of the instigator early on. I think 2003 we got started with the Idaho Fair Housing Forum. We took a hiatus, kind of in conjunction with the pandemic and a couple of other issues, and we've got interest in restarting this. And the forum, for those of you who aren't familiar with it, it's a kind of a safe space for everybody who's impacted by the Fair Housing Act, which is all of us. Gets a chance to kind of share information. Some of the partners, we pool our resources to provide, outreach and education, and work together on areas of common interest. So that's kind of the basic idea of the forum. And you can look at fairhousingforum.org. I'll put the link in the chat here, and that kind of gives you lots more information about the Fair Housing Forum. So we are fortunate to have Brian Stevens with Intermountain Fair Housing Council. He's an attorney with them, and he is filling in for Zoanne Olson, who had a last-minute family emergency come up this morning. So we really appreciate Brian stepping in and taking over the this presentation today. So I'm going to go ahead and hand it over to Brian without further ado. Oh, and I guess if anybody wants to put your name and affiliation in the chat, you can. And I just reminded myself that I have a couple of polls. Can you guys still see the poll up on the screen, or do I have to launch it again?
I think you need to launch it again, Eric.
Okay, it is launched. And we have a couple people who have been filling that out. Looks like right now, local government representative is in the lead, followed closely by housing industry professional and social service provider or case manager. We'll give folks a minute to kind of answer that real quickly. This is just to give us an idea of who's in the audience. Okay, so local government representatives, looks like you're going to win on this one so far. And I'm going to go ahead and end that poll. And I've got one other, just getting to know folks. Let me share the results here first. Okay, and then our next poll, let's see. Current level of knowledge. So go ahead and let us know what your expertise is in terms of fair housing at this point in time. Not seeing any wizard levels yet. I know there are some out there. Oh, 2 wizard levels. That's great.
Eric, I'm not a wizard. I just been around a long time.
Hey, Jerome, good to see you. All right. Okay, looks like we've got a few level 2s who have attended some training at some point. And I'll share the results here, and then we'll move on. All right. Brian, take it away.
Thanks, Eric. Can you see the first slide there? Well, thank you for coming here today. And I just want to say my name is Brian Stevens. I'm a staff attorney at the Intermountain Fair Housing Council. Zoanne Olson was supposed to be here this morning, had something come up. and I'm filling in. So just stay with me here. I gave this presentation at U of I Law School just recently. So I have done this before, but was not expecting this morning. Also, I just say that I noticed there are 2 wizards attending. So I don't know if I'd ever say I'm a wizard, but I do encounter these issues quite a bit. So with further ado, I'll just start the program here. And this slideshow was created during our 50-year anniversary celebration of the Fair Housing Act, and I'm using it. So some of this stuff was not prepared by me. First off, I think an organization always likes to do a land acknowledgement, to just say that here in Idaho and here in the Valley that we have unceded lands from tribes that were here before. And that does have an integral part in the Fair Housing Act, being that we're trying to correct some things that have happened systemically throughout our history. So just take a second to acknowledge that. And if you're not familiar with us, IFHC is a nonprofit organization. Our mission statement is right here. We try to advance equal access to housing for all persons without regard to the protected classes, or race, color, sex, religion, national origin, familial status. We also have gender identity and sexual orientation, source of income, and of course, disability. We attempt to eradicate discrimination through education of fair housing laws, housing information and referrals, counseling, enforcement, including filing complaints under the Fair Housing Act, which includes with HUD and in federal court. Just a little background on, and something I will say here before I go any further. If a question comes up, we do have a question section at the end, but if something is coming up in a slide or a question generally, you're confused about something, I'm okay with just putting your question in chat, and then my colleague Sarah will interrupt me, which is totally fine. And I'll try to answer that question, or I'll save it to the end. So just a procedural thing there. So what is the Fair Housing Act? A little bit about it. It's Title VIII of the Civil Rights Act. After the assassination of Martin Luther King Jr., we had a lot of willpower in Congress to do this. Initially, it included race, color, religion, and national origin. In 1974, it was amended to include sex, which includes sexual orientation and gender identity due to some recent Supreme Court opinions. And in 1988, disability and familial status were added to the protected classes. And, you know, that was at the result of a lot of disability rights actions at the time. So now it has all the protected classes that we know today. So here are the elements of a fair housing case. You know, you first have to have a member of protected class who was discriminated against. Everyone attending belongs to a protected class. So you have to have that they were discriminated against. You have to have the dwelling is covered under the Federal Fair Housing Act, which varies for the Idaho Fair Housing Act. So we're just talking about the Federal Fair Housing Act here. And, you know, they do 4 or more units. You rent 4 or more units of housing or property, or you're in the business of housing. And there are some other examples that are not included here that also bring up jurisdiction. And it's within the time limitations. So every action, you have to actually get it to HUD and file a complaint within 1 year from the time it happened. And then it's 2 years in federal court. And there's some other intricacies to that as well, but I won't go into it here. And then the discriminatory act occurred, and it can include application for screening, denial of a reasonable accommodation. We will get into reasonable accommodations, and different policies, charges, or treatment. So that's just the basics. What type of housing is covered? There are many types, from condominiums to manufactured homes, of course, multi-unit dwellings, seasonal bungalows, private homes, homeless shelters, shelters for victims of domestic violence, hospice, nursing homes, and assisted living. All of these are included, and some of them are included depending on how long people stay there as well. So it applies to many different actors. It includes everything from advertising media down to condo and homeowner associations, rental agents, housing agents, managers, bank savings and loan, in particular, whenever you have like redlining procedures or home loans, developers and contractors, when you have design and construction. So all of these are included. It's a very long list. It can also include cities as well. These are some examples you can find this section in the US Code at 42 USC 3604. And this just from the statute. So you fail to accept an offer. So someone from protected class makes an offer on a property, and then you just fail because of their protected class. You refuse to negotiate with someone. There is a case where two Black individuals were trying to rent a house, and the landlord said that she could not rent to them due to the color of their skin, because her husband would not allow it. And that was a big Ninth Circuit case where they actually decided that the damages were higher because emotional damages just for discrimination actually resulted in a de facto amount of damages. I won't get into too much. I get into this quite a bit at work, so I just wanted to share that. Using different qualification criteria on applications, you evict someone due to their protected class, conditioning availability on response to harassment, harassing someone until they leave, and using planning and zoning regulations to prohibit certain uses. And we can get into this a little bit more. So their terms and conditions is another big discriminatory practice that sometimes happens. So you fail to make repairs, fail to process an offer, limiting use of facilities, the sexual favors for tying for services that include sexual harassment and hostile living conditions, and then harassing people when they use services. So discriminatory statements, basically you have words or pictures hinting or implying is only available to a certain type of people or unavailable to certain types of people. And then you're telling people that a place is available or only available to certain types of agreement. And then it can also be the changing terms in advertising. And here's an example. If you just say that, this ad says, probably comes from the 1950s, whenever there were a lot of very discriminatory housing practices, and is sending a signal that, only maybe a white couple can come into this. And I don't see any children here either. So this is an example of, an ad that could be seen as, something that's not really being very inclusive and could end up with other things. Steering is another thing that's seen. Here's a example of redlining in Seattle. And this has been covered a lot in the media recently, where you have housing and real estate agents that say different things to different people based on their protected class. Color plays a big role in some cities, where real estate agents will steer or direct people to live in certain neighborhoods based on the fact that of their protected class, telling them that it's a good neighborhood for them, and then coming back and telling a white family that that's not the neighborhood they want, and these other neighborhoods are better for them, failing to even offer places. And then I also see lying in response to harassment. So, you know, that's steering. And if anyone has any questions about that, it's basically just segregating communities based on a protected class. And this is another common violation that I would just mention here, and something I mention in a lot of my cases. 3617 makes it illegal to coerce, intimidate, threaten, or interfere with any person that exercise enjoyment. The courts have a very liberal standard of what that might entail. And whenever someone has exercised their rights under the Fair Housing Act, any interference with that or coercion is something that we really look at in our cases. And if someone is exercising their rights and someone's interfering with that or trying to coerce them from seeing out their case, we have taken that very seriously. So here's a rule can get you in trouble as well. And this is an example of that. This rule would look, a rule may look neutral, but whenever it's actually in practice, it may be very discriminatory. So if you said something like, no BYU grads can live in this building, on its face, it may look like, oh, well, you have something against the school. But because a lot of people who attend BYU belong to a certain religious group, it's very likely this would be seen as discriminatory based on religion, you know, in code words and things that may look neutral on its face can get a housing provider or someone covered under the act in trouble under the act. You know, one thing that this slideshow points out is that an-ounce prevention is really key here. You know, you have to ask, do you really need the rule? And then can you rewrite it so that it doesn't affect people? So here we have, you know, a dress code that may look neutral on its face, but it would definitely be something that's very questionable under the Fair Housing Act and other discrimination statutes. I mean, you've got overly baggy clothing, long t-shirts, you know, political t-shirts. You have a lot of different rules here, but you know, person putting this out could easily reword this so that it's not targeting a specific group or perceivably doing so. If you or someone you know does have a discrimination complaint, and I went through this before, our organization helps people file discrimination complaints. They have a year to file with HUD, and HUD can find there is reasonable cause and charge the case. And it could go to trial before an administrative law judge, or it could go to court where the complaint is represented by the Justice Department. So that's the administrative process through HUD. HUD is the Department of Housing and Urban Development, as many of you are aware or may be aware, and they enforce the Fair Housing Act as part of the executive branch. There's also another way. You don't have to go through the HUD process, and a private attorney can file suit within 2 years of the alleged violation. It can be filed at the same time as the HUD complaint, and it is not dependent on the findings of HUD. So if HUD does not take action on a complaint or finds that it's not caused, then a civil case in federal court could still go forward. And those two actions are independent of each other. I would just say that it's unlike some other administrative laws. This slideshow includes some hot topics as well, and here's a link to that. A HUD criminal background check guidance. This entails where someone has a criminal background that's connected with a disability. And you can check references, you can check ability to pay rent. You can create rules to benefit the entire community. I've had a few talks with housing providers just recently about how things that say no criminal history violate the Fair Housing Act, because it's more of a case-by-case factual analysis that every housing provider should go through, just to make sure, one, that they can make that reasonable accommodation and they're not deterring people who may need reasonable accommodations. For one example, addiction is covered as a disability under the the medical associations see that as disability. It's still seen as a disability under the Fair Housing Act as well. So if someone's taking measures to be in rehab and be in therapy, and they're not using drugs anymore, that is a reasonable accommodation that is used. And this is just going over that some more. The landlords cannot screen and deny for all criminal history. You can say that your convictions pose a threat to tenants and other property. Here it says murder, compared to trespass. And you can imagine the types of crimes where it might pose you might see a pattern that poses a risk of violence to your community or other things. And also just to establish how old is it. So if it's 20 years old, are you really being fair to the applicant? Or again, if it's connected to disability, have they taken measures to mitigate? Our recommendations are you don't ban people based on anything other than convictions, not more than 7 years old. You don't blindly follow background check support services, because they can be inaccurate. I used to be a prosecutor, and I've had cases where the federal background check on people has been inaccurate, and we've had to correct things. That's just I think it's one of the highest levels of background checks, very private, but even then there are mistakes. So allow a process. So if someone is wrongfully accused of something, you're not just denying them. And then if you do deny someone, put it in writing, so that there's a record created. So you're not just they can't come back and say, well, you're only doing for this. But I'd recommend putting it in writing. And then, of course, like I've been talking about in a couple slides back, a person with disabilities may ask for an exception or reasonable accommodation to your housing policy for criminal background check. And there are certain situations where that is reasonable. And here are our best practices: have a reasonable conviction screening policy. Legitimate interest of the policy. You want to make sure people pay their bills on time, maintain the property, respect other residents and staff, that they comply with the rules, policies, and that they further community safety. No automatic conviction exclusions. Ignore arrests. Someone could be arrested for something, but the way I look at it is, unless you're convicted and you plead guilty, you are innocent until proven guilty. That's where our system works. So taking someone's arrest and using that against them could be, I mean, it could be a factor in assessing where a fair housing case may come up. Apply policy equally and consistently, individually assess records and conduct. You have narrowly tailored inquiries, you train your staff, and you monitor the impacts of the policy. So that's our best practices. Another one is, and Idaho is growing and it's changing. We also have a very big refugee population. So this is a big thing that is coming up here. The LEP, the limited English proficiency, people who do not speak English or do not speak it that well. If you are federally funded, you have to have a language access plan, and you need to have a language access policy, provide interpretation, then monitor and evaluate your programs. You have to have procedures in place, staff training, engage in affirmative marketing, and then the translation of vital documents. I mean, I think it's a good housing practice. So you're, reaching out to as many people as you can. It's also if you receive federal funding, it's also a requirement. And there is a link here for the HUD guidance on the LEP. And also I just put in here, and it's just right here in the slide. If you treat people differently because they are LEP, limited English proficiency, that can easily be seen as a national origin disparate treatment. And here's some other resources. The U.S. Department of Justice has an LEP website. It's very easy, lep.gov. The courthouse and Boise interpreters are a good example of where to find interpreters. You have universities here, agencies, community groups. We have a link for language access guide. There are apps, several apps have been developed under this. And then a local Idahoan who used to work for HUD, his name is Gary Haynes. He runs a consulting agency that helps businesses and cities comply with LEP and language access plans, right? He's very knowledgeable about the subject. So getting back into, just the Fair Housing Act basics, another big portion of cases that we see is disability discrimination under the Act. A person is disabled if they have a physical or mental impairment that substantially limits one or more major life activities. They have a record of such impairment or regarded as having such impairment. It is broadly defined, and I would just say that a lot of people get confused when you talk about disability because there is a Social Security Administration definition of disability, which means you can't work any job. That is not what the Fair Housing Act is thinking of when it says disability. It really does mean that you have a physical or mental impairment that substantially limits a major life function. And that can include anxiety, it can include things like depression, it can include something you cannot see that's not apparent to the naked eye. So I'd just be aware of that. There's two types of reasonable accommodations. There's reasonable accommodation, and there's a reasonable modification. And I would say that the nature of this is a bit different, and the slides tell this, is that most of the time the Fair Housing Act says you have to treat everyone the same way. Reasonable accommodation and modifications you're actually treating people differently, because as a housing provider under the Act, you have an affirmative duty to provide these reasonable accommodations to make everything equal. So, and you're just doing this with disability. It's not that you're doing this with other protected classes, but the idea is that you're bringing everything up to a level playing field. There is guidance under this, and I would, if you are interested in this, the guidance I think does a good job of walking through in Q&As. and it's the federal agency's interpretation of its own regulations. There are Ninth Circuit decisions giving great weight and deference to these interpretations of the regulations. So the difference between accommodations and modifications: an accommodation is a change in rules, policies, practices, or services that are necessary, and the housing provider bears any cost involved, but it's not a change to the property like a modification would be. A change to the property is an actual physical modification to the property, such as installing lights for someone who is deaf. It can include a ramp. It can include other modifications like having a shower bar in the bathroom. Some of these are required when new property, which I don't know if we'll get into today, but that's basically it. And if you receive federal funding or you're in federal subsidized housing, you have to pay for the cost as a housing provider. If not, the tenant would have to pay for it. And if it leaves the property different in some way, that they might have to actually go back and repair the property when they're done. So you have requesting accommodation or modification. This is I would say a very liberal standard approach that the courts have taken, and it doesn't have to be in writing, but it's better if it's in writing because you're creating a record exactly of what you're requesting and everyone's on the same page. But the courts have seen it where you can make it verbally, and that will count as a reasonable accommodation. It doesn't have to use any form. A person can simply write down that they need an accommodation, they need it because of their disability, and that will qualify as a reasonable accommodation, even though they may have not even used the words reasonable accommodation under the act. But if we're using best practices, it should state the person has a disability. It doesn't have to say which one or the nature or extent or the severity of that disability. And the person needs the accommodation because of their disability. And that such an accommodation will give them equal use of their housing. Sometimes a disability is apparent. In the picture here, we have a person walking with a cane who's blind. Of course, if a blind person asks for an accommodation, it's very apparent that a person is blind. So asking them for a proof of need would be a problem. Or a person in a wheelchair, for example, doesn't have use of their legs. It's another apparent one, but sometimes, like I said before, it can be that it's not apparent. So if it's not apparent, you can ask a reliable third party who is in a position to know about the individual's disability. This can include doctors, social workers, counselors, caseworkers, and it can include a family member. It's basically in a person who's reliable, a third party who knows about the nature and extent of the disability, and the letter verifies the existence of the disability, the accommodation or modification, and that this person needs this accommodation or modification for the equal use of their housing. This is what our organization recommends that gets people in trouble under the Fair Housing Act and leads to cases going further. Do not ask about their diagnosis or any other questions about the nature or severity of disability. It's a very private thing for people with disabilities. And I think that, once it's out there, I think you're putting yourself at risk as a housing provider or someone under the act, because then you could discriminate against them based on what they're doing. And I think it's just, you just don't need to know it. You just need to know that person's reliable and they're verifying it. You don't need to directly contact the person who fills out the proof of need form. We've had cases where, doctors have reached out to us stating that someone asked about the nature and severity. We're asking inquiring questions about nature and severity. They don't want to talk about it because they don't have a HIPAA release. And their doctors especially are just very hesitant to break any kind of privacy. And I understand that, being an attorney. We ask that you don't ask them to sign a HIPAA release so the doctor can state it. I know there is HUD language out there stating that you can contact the person to see if they wrote it. So I'm not going to talk about that, but the closer you get to the line on these cases, the closer you get to a case coming about. Delays can be treated as denials. Usually we'll write it with a timeline to respond by, and don't charge a fee for an accommodation. If you charge a fee, that can be seen as a barrier and it can violate the Fair Housing Act. When can you turn down a request? Well, this does happen. If the person doesn't have a disability and they're asking for accommodation, well, they don't fit under the act. The accommodation they're asking for isn't related to their disability. If someone asks for pay no rent at their apartment complex because of their disability, well, I mean, that isn't necessarily tied in to their disability, or there's recent court opinions that go into this, but it has to be directly connected. There has to be a nexus there. They're trying to ask you to provide services for them. That's not covered under the act. It's unreasonable, and considering, and I think these are high bars, the cost of accommodation, the housing provider's resources, the benefits of the accommodation, or the availability of other accommodations. So they can request things, and you can proffer back in the interactive dialogue is the language that another accommodation may be used. And that's certainly part of the interactive dialogue. I think I covered everything here. And then for modifications also, if the person doesn't get the required permits or they do a shoddy job, that can also be part of it. The thing I would recommend here is best practices. You don't say no. If you can't give them what they initially asked for, you get an interactive dialogue with someone who's just trying to live at a property, who wants to be treated equally and be put on a level playing field with others. So I would recommend that you just enter into an interactive dialogue and you actually get in a conversation, because sometimes an accommodation can be made and everyone can be much better off than being put through a whole fair housing case. Commonly requested accommodations: additional time to move out, people with mobility impairments. I have a case, a very humane case that just happened with a veteran who's much older in years and very disabled, and had been living in a place for more than 10 years. And it took him considerable time because he was dependent upon other people to move. And we were very lucky to, have someone who knew about the Fair Housing Act and honored his accommodation request for more time to move out. And that case ended very happy for everybody. You waive a no co-signers rule for someone whose only source of income is disability, or because their disability doesn't allow them to work or have an income, and there is a co-signer there willing to take responsibility. You assign parking spaces for people with parking cards, mobility impairment. You overlook a previous eviction or arrest because they happen during untreated mental illness, if the individual has taken steps to eliminate the previous threat. I spoke about that earlier, just to reiterate that. And then this is a big one that's happened here in Idaho: allow a group home for people with disabilities to operate in a neighborhood that tries to prohibit them. That is also violates the Fair Housing Act if you say that you're not going to allow that group home into the community. And of course, animals. Assistance animals are a big thing. There is 2020 guidance was to clarify HUD's analysis. I just want to put a note in here. We think that given that the rescinded 2013 guidance Well, I'm not going to talk too much about this slide, but there is guidance out there, and of course, everything is changing. But I'll just leave this slide here, basically to say that, there are some procedural things that happen with this HUD guidance, and to, I would say, follow the interpreted HUD guidance that has been approved, and the more approval, the more deference courts give it. But I'll just leave it at that. I believe HUD will probably be giving more guidance to that, and there's always the DOJ guidance that I think is very right on track. Just to here you have a Marine veteran with his assistance dog. These animals are not just for blind people anymore. I mean, they help people with PTSD, anxiety, diabetes, and other disabilities, and they can make a great effect in people's lives. So they really are like a prescription drug. They really help people. And I did just have a case where a person was denied a service animal, and then they received, after they were approved, they received a very large payment they had to make for having that service animal, and that was the case we handled. And that you can't do a fee or any kind of barrier. This is a slide that shows, so the difference. A lot of people are confused because you have the American with Disabilities Act, which is everything in the public, and you have the Fair Housing Act, which is everything inside the home or inside the apartment complex. So the rules to public spaces that are under the ADA do not apply to animals under the Fair Housing Act. And I can't be more insistive on the fact that you should not get these confused, because under the ADA, it has to be a dog or a miniature horse, and it has to be trained to perform a task. That's something the animal normally doesn't do. So, and these are very stringent requirements because it's in the public. Assistance animals are under the Fair Housing Act. You can't say no species or breed restrictions or age restrictions.
Give me 1 second, please.
There are.
Sorry. I'm trying to mute here.
There are there are situations where they can be more than one, and it doesn't require any training. And they're also people call them everything under the sun. So you can call them assistive animals, emotional support animals, service animals, therapy animals. The name does not change where it is. It's all about where it is occurring. And that's what I always stress upon people, is that it matters where it is. Okay. There's no distinction between any of, so what's the difference between any of these animals? There's no distinction, different types of animals. They're seen as reasonable accommodations for disabled individuals. So I would just stress that, it has to be a case-by-case scenario. Whenever you're looking at these are things you shouldn't do under the Fair Housing Act. Don't charge a pet deposit or pet rent. These are seen as barriers. Don't restrict the species, breeder, size, weight, or age. Unreasonable restrictions on the animal. You can't say that they have to get a proof of need from a particular provider. We recommend you don't call the proof of need provider because it just puts you at risk under the Fair Housing Act. And don't put an unreasonably small cap on the number of animals. 2 birds or 2 cats is okay, but this should be a case-by-case scenario given, given some of the things we'll talk about on the next slide, or in a couple slides, I guess. And then don't treat people differently or worse. I had a housing provider call me the other day when we were talking about a case, and they wanted to do a blacklight testing for anyone with a service animal, asking if that's okay. Well, if everyone who ever moves in gets a blacklight inspection, then you're not treating people differently. But if you're only doing a blacklight inspection for a person with an animal, then you're treating your people with disabilities differently than how a person without that accommodation would be treated. And that's a very big point, because I think housing providers want to do that sometimes. So we have some cases here that just show you that, the courts do look at these animals as covered under the Fair Housing Act, and that deposits, especially here in Idaho, and I would say that in more places in Idaho, but especially here in Idaho, under a court decision, you can't require a different rent. You can't require a pet deposit. It's banned. You can bill someone if their animal causes damages to the residents. You can require them to have a plan for taking care of the animal or dealing with animal waste. And it's okay to require that the animal is well behaved and not creating nuisances or problems or threats to other tenants. I think a lot of people are scared that, it could be a scam. Scams do exist where people state that they are these physicians or people that okay these service animals. If you think that you're being scammed, just remember the person with a disability may be scammed as well, and they might just be pulling they might just not be pulling a fast one. They might actually really need that reasonable accommodation, and you may just want to help them get to someone who's trustworthy and get a proof of need, because a proof of need does actually exist and you just outright deny it. That could be a problem, because they're going to eventually get that proof of need from a reliable source. There are situations where HOAs, cities, and insurance companies give an ordinance or something that stands between a resident and their animal. If that happens, you can request a reasonable accommodation. You can reach out to our organization that would talk to the HOA, city, or insurance policy to help you with that, because you may need reasonable accommodation being a housing provider, and there may be some extra steps in there. Can you provide or impose restrictions? You can't impose blanket breed, size, or weight restrictions on assistance animals. You must approve an assistance animal's reasonable accommodation if keeping the particular animal is feasible and practicable. You can do a specific animal assessment. So, I mean, if there's a Dalmatian, that's a very hostile and violent dog, then that Dalmatian can be banned. But if you said all Dalmatians, that would not give people the space they need to, if they have a very well-trained Dalmatian and it poses no threat to anybody, you could end up having a fair housing case if you just said no Dalmatians. Can the provider restrict where an ESA may be present? So the person with a disability with an assistance animal can take that animal in all areas of the premises where persons are normally allowed to go, unless doing so would impose an undue financial or administrative burden or fundamentally alter the nature of the housing provider's services. So you cannot prohibit an individual from taking his or her service animal into common areas, especially if you're not going to have that huge unreasonableness. So best practices, housing providers, we're not their doctor or counselor. Doctors and counselors, the experts here, they know their patients, they know the existence of their disabilities and the extent to them. And then they decide whether there's a nexus there. If the visitors and guests need assistance animals, they should get to visit. Don't prolong the process, just answer them and enter into the interactive dialogue. And we recommend you just document everything, because if we get a case where we think someone's being discriminated against, your documentation goes a long way. in trying to investigate that. We are here as an organization to help in this process. We fight discrimination when it comes to buyers, sellers, landlords, HOAs, cities, insurance companies, neighbors on neighbor harassment. We have sample forms, we have position statements, we have resources on building housing. We prevent and alleviate homelessness. We work on preventing new and inclusive housing. We provide, like today, we provide training opportunities for multiple groups. And this slide does not include me, but I will just say I really do work here. And if anyone has any questions, I think we have some time.
Yes, if you want to go ahead and throw questions in the chat, or you can raise your hand and we can unmute you, whatever is easiest for you. And if we have no questions, then maybe either we can wrap up earlier, or I can just think of some more things for Brian to talk about. Not seeing anything yet. If you...
Sarah, what time is this supposed to go until?
That's a question for Eric.
11?
I've got a question.
Okay.
Go ahead.
This is David Penny at Tomlinson and Associates. Brian, I certainly appreciated your presentation. Could you talk more about the interactive process and just what you see there and how it works, and I don't know, just your comments and thoughts about the interactive process on requests for accommodations.
Yeah, I think that's a good point, David. The interactive process, I think sometimes people will make reasonable accommodations requests, and they do need an accommodation. But I think there's a lot to be said whenever a housing provider can come forward and say, well, this is going to hurt the nature of our operation or fundamentally alter it, be a cost. But what if we did this instead? You want, sometimes people will say, well, I can't, have my assistance animal, on a short leash, or I need, accommodation in some of the rules of the building. And I think I'm being pretty vague here, but I think the nature of it is that sometimes a housing provider has all of these resources and thinks about their business in such a way that opening up the dialogue to say, like, we have all these other things that we can do that fit into our model. I think that can lead to something that helps out the housing provider and something that helps out the person with disabilities who's trying to get the accommodation. And entering to that process from the very beginning, I think goes a long way for resolving some of these accommodations that come up, instead of if you just say no, then it can start to be a very combative process, which I think a person with disability shouldn't have to go through. And I think it just hurts you as a housing provider, because it may create a problem where something can be solved through a little bit of innovation and thinking outside the box. So I do really encourage people to start with that interactive dialogue and to participate in it. I think it helps solve a lot of problems before they get to a level where it is a problem. Is that?
Do you foresee that there's a good faith point there that, here we're supposed to respond to requests for accommodation on a timely basis, as long as the housing provider and the requesting party are acting in good faith in their, question and answer and working to solve the problem. Is there a time constraint on the interactive process?
Well, I think that, the reasonableness is a very, as you know, David, the courts look at reasonableness, and they look at probably under what I would say is a totality of circumstances approach. So, it really depends on the nature of what people are asking for, how long of a period it takes, and other factors as well. I think it's best to, when you're making these accommodations, to give a timeline for response. And I would just, I'd say don't sit on your hands, because this person with the disability may really, really need this accommodation, and it may become a bigger problem if you let the situation go for a while. And I do have cases where it's a month occurs between the reasonable accommodation request and then us getting involved with no answer. And I would say at that point, if you let it go for a month with no response or no dialogue or anything, I'd say that that's a problem under the Act. And there's no particular timeline. It's a reasonable thing, but it's just being on top of things, I think, really helps with things like this.
I agree. Thank you.
All right, it looks like we have another question from Tatum Benjamin. If you have a client with a felony conviction for substance abuse, but they are in recovery, can you still write a reasonable accommodation for them?
Thanks for your question, Tatum. The addiction and, the convictions that happen because of addiction, I do see them as being covered under the Fair Housing Act, and we do work in cases like that. The biggest part of that is that someone is taking steps to mitigate the ill effects of that disability can come with, and the risk to the community and other people living in that housing complex. So, if, I've had cases where, a person is in recovery, they do have a conviction, but they're doing well in their recovery program. They have letters of support. A big one that can be very convincing in these cases is if there's a probation officer who says, yes, they're staying clean, they're doing really well, things like that. So yes, it can be a reasonable accommodation under the Act, and that can come up, and that's what I spoke about towards the beginning of the slides. But if someone needs a reasonable accommodation, that can be met. It kind of goes towards their therapies and progress they make on overcoming the addiction. But yes, that is a disability. Thank you.
All right, it doesn't look like we have any more questions. I'm going to drop our social media handles in the chat. If you have questions, we answer a lot of this stuff regularly on our feeds. So give us a follow, or you can reach out to us there, or you can email us if you come across anything later.
Yeah, and the one thing that I'd like to mention is that we regularly recruit people from different demographics, and we have a lot of testing going on, and we have a tester training November 19th at 10 a.m. and December 7th at 1 p.m. If anyone is interested in being a tester, of course, you can be a housing provider or an attorney for a housing provider. But if you're just someone who's interested in this and doesn't have any connections, I would really recommend you try it. It's a great thing. And it's an integral part of just keeping everyone compliant with the Fair Housing Act. And I think Sarah has some links that that she can drop. It's also available on our events page. So I would just really recommend that if anyone has any interest in being a tester.
Looks like Jerome Mapp has a question. Jerome, you can unmute yourself.
There you go. Thanks. As a city planner, we deal with fair housing in a different manner because we have developers come to us to receive approval of various development projects. We have some that say, well, this is going to be a senior project. And they want to base their approval because of their connotation. What are some of the things that we need to be aware of when we're doing a review on a project when it says it's going to be a senior project, or when they have the project say they're going to put playgrounds and they're steering residents, into that area of the project because they have a playground in that area?
Yeah, well, thank you, Jerome, for that question. I do think that happens. Well, first I'll start with the senior housing. My understanding that there is senior housing, of course, would affect people with families, but my understanding of the act is that there is an exception for senior housing under the Fair Housing Act, since it's from its inception that that building or that development is planned as senior housing and it follows all the rules. There are several steps I think you have to take to, be a senior housing facility, and there, without getting into all the specifics, we could talk later. You could also talk with our executive director in a separate meeting, but basically, as long as they're following all of those steps, senior housing is accepted under the act. The other thing I would say, as far as the steering that goes on with a family and putting them over where the playground might be, it's okay to tell people this complex, has no playground, and this complex has a playground. A person with a family can choose either to live in the complex with no playground or the one with the playground. You just have to give them equal access to both properties and let them decide for themselves where they want to live. There could be all sorts of considerations that a family might give that tells them they don't want to live near the playground. That can include, access to other resources or neighborhoods or schools. But yes, steering someone towards the playground and putting all families in one place, I think would violate the Fair Housing Act, even though someone might not be doing it out of spite, but you just can't channel a protected class into a certain community. I hope that kind of answers that question. That's the way I see it, Jerome.
Thank you.
Cool. Well, I have dropped some information in the chat. We have a tester training on November 19th at 10 a.m. and then one on December 7th at 1 p.m. If you have questions or are interested in that, please contact A. Chavez at ifhcidaho.org. Follow us on social media. We post lots of information and you can contact us there and ask questions. Do you have anything to close out with, Brian or Eric?
Well, I just want to say thank you for everyone being here. And I think that we all, I think by being here, you show that you want to comply with the Fair Housing Act. And I just remember, whenever you're doing these things, making reasonable accommodations, being compliant, I mean, it provides an overall service to the community that I think the Fair Housing Act goes a long way into bringing everyone into a more equal footing when we're talking about something that is very integral to all of our lives. I mean, it's housing, it's where you live, it's where you, the last refuge that we have in our lives. So I think I just remember that, and thank you all for being here, and I'll let Eric end it here, but thank you, Eric, for having me.
You're welcome, Brian, and thanks again for stepping in at the last minute. Really appreciate your expertise and great presentation, by the team back at Intermountain. And thanks to the folks that had questions, Jerome and David, appreciate that, and Tatum. And I dropped a little note in that chat as well. In the future, our plan is to give folks a little bit better notice on these, and we'll be issuing a monthly e-newsletter that'll be pretty brief, and the invitation to the next meeting will be embedded in that newsletter. And we're hoping to put that out the Friday prior to the Wednesday meetings. And I'll be posting more information on this training today at fairhousingforum.org, so you can kind of consult that. I'll try and keep that current, within a day or so of each session. So I'll have a link to this video there and link to a couple of other Fair Housing Basics videos that have happened in the last year, just to give you a little bit more information. A lot of it's the same, but we do have lots of training sessions linked from that website, and as well as Intermountain Fair Housing Council site. So I'm also putting in a link to the housing or the home preservation program. That's the emergency rental assistance through Idaho Housing and Finance for folks impacted by the pandemic. So if you know folks that need help with rent or utilities, reach out to them, to that program. And then if it's in Boise or Ada County, then you would go to Boise City Ada County Housing Authority, and I'll put that link in there as well. Let's see. And then Crystal or Brian Dale, you guys want to add anything?
I really didn't have a lot to add today. Thanks so much, Brian, for your presentation.
Thank you, Brian.
Okay, so there is the link to the Boise City Ada County Housing Authority, the ERAP program. And then we have one last poll. Just going to take a second here, get that set up. And this would be, we've kind of pre-selected 3 possible topics for the December meeting, and I'll launch that poll now. So let us know which of these 3 issues you'd like us to discuss. NIMBY is something that's pretty pervasive these days, and it's become a real issue. Also accessibility in terms of housing and community infrastructure, and then additional landlord training for maybe more advanced topics, focusing in on specific items. Okay, give folks another 15 seconds or so to weigh in. Oh yeah, thanks, Sarah. NIMBY, not in my backyard. We also have the acronym CAVE people, which is Citizens Against Virtually Everything. Brian Dale knows that one well. Okay, looks like maybe NIMBY is going to be a topic for December. So that's a pretty wide open topic, and I think a lot of it, tends to touch on fair housing issues, either directly or indirectly. So we'll put something together on that and get the word out to you the Friday before that Wednesday, which I think is the December 15th. But I'm date and time challenged today, so I'll put it in writing to you guys. How's that? All right. Thanks again, everybody. Thanks to everybody who participated today.
Thanks, Eric.
Have a great week.
Thank you.